Hi, Emily from Apex Law School Prep and Support, here to wrap up the California February 2023 exam with question 5. So it's a bit of a longer hypo, goes on to a second page. We're going to try to be as efficient as we can. Let's start with the cause of the question. So assuming all proper objections and motions to strike were timely made, should the court have admitted? So objections and admitted tells me this is evidence. Number 1, the photocopy of the advertisement, discuss. So photocopy makes me think of best evidence rule. In California, we call it the secondary evidence rule. That's the rule that says if you're trying to prove the contents of a piece of evidence, some tangible piece of evidence like a picture or a video or an x-ray or a document, if you're trying to prove what it says, right, what its contents are, then you're ordinarily supposed to offer the original or a machine duplicate, like a photocopy, subject to some exceptions, right? But you're supposed to offer that original or a machine duplicate instead of like the second best evidence, like testimony about what it says. So photocopy is always going to satisfy that, but I'm going to IRAC it. And then of the advertisement, it makes me think of hearsay. Presumably this advertisement contains some kind of statement and it was made out of court in the ad. So I'm thinking I'm IRAC hearsay. We'll see what else. Question 2, Pedro's testimony about the value of the painting. Okay, see, Pedro's testimony makes me think witness requirements, perception, memory, narration, sincerity, personal knowledge, that stuff. And then about the value of the painting, that sounds like maybe expert territory to me. I don't know, maybe expert opinion. Number 3, Rex's testimony, witness requirements again, about the age of the painting. That again, maybe expert opinion. Number 4, the excerpt from The Science of Dating Works of Art, discuss. So an excerpt from like a book or a journal or something. So I'm thinking hearsay, particularly like document exceptions in the event that it qualifies as hearsay, because it's, document. And then I don't know, maybe like authentication and stuff like that. Number 5, Rex's journal article, discuss. It makes me think of the same stuff, hearsay with like document exceptions and I don't know, authentication, things like that. We'll see. Okay, answer according to the federal rules of evidence. Okay, so take all the like Prop 8 and California stuff and just throw it away. Okay, let's get started with the fact pattern. Pedro brought a fraud and breach of contract action against Gallery in federal court. Okay, federal court, we already knew. Fraud and breach of contract. So this is civil. Okay, at a jury trial, Pedro testified that he purchased a painting from Gallery for $200,000 after seeing an advertisement, that's number 1, bearing Gallery's logo, stating that the painting was the only painting by a noted 17th century artist available for sale in the world. Okay, the ad says, it's Gallery's ad, right? It's got their logo, and it says this is the only one of its kind, and it's 17th century artist. Okay. On Pedro's motion, a photocopy of the ad was admitted into evidence. Okay, so that's question 1. Pedro also testified that the painting was worth only $10,000 because it was a reproduction of the original, and that he based his valuation on the average of 3 appraisals of the painting by art dealers. Okay, that's question 2, right? His testimony about the value of the painting. Okay, I'm just skimming to see if there's anything else in this fact pattern about this. I think that paragraph is it. So on an exam, I would never start writing until I had read through the whole fact pattern in case they bring up more stuff about this. But I think that's all that's in this fact pattern about those 2 things. So let's talk through 1 and 2. Okay, so number 1, the photocopy of the advertisement, discuss. So first of all, there's 5 pieces of evidence that they're asking us about here. This is racehorse, right? I gotta be really efficient with my time here. For every piece of evidence that they're asking about, I'm always going to start with logical relevance, and then I like to end with legal relevance. You can also put it right after logical, it doesn't matter on the exam, but I'm always going to be IRACing both of those, and then what I put in the middle, or whatever other IRACs are plausibly triggered by the facts. So for this photocopy of the ad, I would start with logical relevance. He's suing for fraud and breach of contract. Presumably saying that he was defrauded by this ad that said it's, the only painting by this noted 17th century artist in the whole world. And it turns out that it's only worth 10,000 because it's actually a reproduction. So I'm going to say logical relevance, really low bar, right? If it has any tendency to make a fact of consequence more or less probable than it would be without that evidence. So I'm going to say, yeah, it makes it more likely that they, defrauded him, that they made a misrepresentation in this ad, if we can show that this ad is, if we can offer the ad showing what they said. So that's logical relevance done. Where am I going to go next for that? Well, the things that jump out at me are best evidence rule and hearsay. So if we think about hearsay, we need to find our declarant. It's got Gallery's logo on it, so I'm going to say Gallery is the declarant. And then I'm going to say number one, like step one for hearsay, is it an out-of-court statement offered for the truth of the matter asserted, right? Is it hearsay? And then step two is going to be, if it is there an exception or an exemption that applies to let it in? So is it an out-of-court statement offered for truth of the matter asserted? It's out of court. It's, he saw the advertisement that stated this thing. So the statement was in the ad. It's a statement. It says paintings only one by the 17th century person. Is it offered for truth of the matter asserted? No, right? Pedro's offering this to show the opposite, right? To show that it's not true. So I would say it's not TMA, not truth of the matter asserted. The hearsay hurdle is not going to be a problem here. It is not hearsay. If you didn't quite know that, or you weren't sure, and for some reason you kept going and you're like, maybe it is TMA, then you could very easily still let this piece of evidence in by saying that this is party opponent admission, which is just any statement by the other side. Pedro's offering it, and it's Gallery's statement because Gallery's logo's on it. So either like it's Gallery's statement themselves, or you could say it's some kind of like authorized, or adopted admission. In federal court, we call that, an exemption. It's just non-hearsay, and it would come in that way. But I think more properly, you say it's not TMA, so not hearsay, not a problem. But you could also, if you kept going, say like in any event, party opponent admission, hearsay is not an issue. Then I would go on to best evidence rule because it's photocopy, and I would just give that rule, but if you're trying to prove the contents, blah, 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 but a photocopy is a machine duplicate, it's treated the same as the original. So here, no problem with best evidence rule, it's just fine. We have to authenticate this advertisement as well. If he's trying to say this is the ad. So I'd say, presumably Pedro has like some kind of personal knowledge about, that this is the ad. So he can testify to that and authenticate it. Or, maybe you could say that like because Gallery's logo is on it, it's like some self-authenticating thing. It's unclear whether it's like a video ad or like print ad, but I would say either one of those will get it authenticated. Authentication is just, you have to show the proponent, right, the person offering the thing. So Pedro here has to offer enough to the jury to have them, right, from which they could like reasonably conclude that it is the thing he purports it to be. So I think that's sufficient. And I think that's all of the meat that I would see for this. And then I would just wrap up with legal relevance before I move on. And I'm going to say, so legal relevance says it's heavily weighted towards admission, right? It's 403 in federal court. You need to know that. But it says like this thing is coming in unless its probative value is substantially outweighed by, this laundry list of things, right? This risk of unfair prejudice or needlessly presenting, cumulative evidence or undue delay or confusing the issues and blah, 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 blah. I don't see any of those being triggered here. So I'm going to say, yes, it's legally relevant. And then I'm going to conclude this ad can come in, no problem. And that's all I'm doing for question one. Question two, Pedro's testimony about the value of the painting. Okay, so that's the second half of this paragraph where he testifies that it's only worth 10,000 because it's a reproduction of the original. And then he bases his valuation on the average of 3 appraisals of the painting by art dealers. Okay. So there's the wrinkle of what do we do with that? So first of all, logical relevance. This is logically relevant, again, to proving like fraud and breach of contract because they said in the ad that it was, 17th century, only one in the world, so like an original, and now he's saying it's a reproduction. And it's, worth 10 instead of 200. Okay, so logically relevant, no problem. Then where am I going to go from there? A couple things. I think so he's basing his valuation. So it's like his opinion is that it's only worth 10,000, but he's basing that on the average of 3 appraisals. So I think one thing you could do is say, insofar as that he is saying like these 3 art dealers told me that it's worth this amount. If we look at it like that, then we can look at these art dealers as declarants, and we can say that their appraisal statements are hearsay. It's not like directly doing that here because he's, basing it on the average of these 3. But I think, that's something that you could IRAC. And say like, I would explain if I'm making an assumption, I always explain it to the grader. I'm like, insofar as, Pedro is testifying as to the statements, by these art dealers, then these art dealers are declarants, and they made their statements of the appraisal value out of court. And so now we have to IRAC hearsay. So for that, I would say, is it out of court statement offered for truth that the matter asserted? Out of court, these appraisals were somewhere else, not in front of this jury. Statement, yeah, whatever they said it was worth, that, something around 10,000, I guess, and that it was reproduction. And then is it offered for truth of the matter asserted? Yeah, he's like, jury, this is what it's worth because this is what the art dealer said it's worth. So yes, it's hearsay, not coming in unless an exception applies. What exceptions would you IRAC? Maybe, for like purposes of having something to do on the test, maybe you IRAC present sense impression. Right, that's, you're narrating an event, like as you're, right, an event or condition as you're perceiving it or immediately after, in federal court. I don't know that like looking at a piece of art counts as an event or condition technically, but I guess, you could try to make some argument of like, well, if the art dealers, as they were looking at the painting, said like, oh, this is a reproduction, like that, then I guess you argue that it's present sense impression. I don't know. I think the rationale behind present sense impression is, we think those statements are reliable because you're like narrating something as it's happening. We say you don't have time to fabricate. I don't really know how appraisals work exactly, but I'm thinking maybe they have to like do some research and like really think on it, before they can just come out and say what it's worth. So in that sense, I would say present sense impression shouldn't apply. I think also like maybe it involves them making inferences based on what they see rather than just like straight up describing what they see. So I think present sense impression is probably a loser. But maybe I'd IRAC it. The other thing I always consider IRACing when I see present sense impression is excited utterance. That's right. If you're still under the stress of an excitement of a startling event, when you say your thing, oftentimes those come up together. This does not seem to be a startling event. They often use exclamation points on a hypo when they're getting at that, or they'll give you some adjective about how the person said it. I don't like, right? Like if they were like, oh my God, it's a reproduction, right? Like they were startled by it. They were like struck, shocked. I don't see any of that here. So I wouldn't bother IRACing excited utterance, but I would think about it. But I think that's all I would do in terms of if we're viewing these art dealers as declarants and saying, this is hearsay. It's definitely hearsay. And then I don't think that present sense impression is a winner. So I'd say it does not clear the hearsay hurdle. What else would I do with this? I think, well, if we're looking then at like he based his valuation, he's saying, right, Pedro's opinion of it's only worth $10,000. That's opinion testimony. So I think, I'm going to get into a couple things. First, I'm going to say Pedro's testifying. So witness requirements. So perception, memory, sincerity, narration, personal knowledge. He seems to have like perceived what the appraisers told or the art dealers told him just fine. He seems like he remembers it. There's no indication that he does not understand his obligation to tell the truth for sincerity. He seems to be communicating just fine to the jury for narration. And then personal knowledge, I guess he has personal knowledge of what the appraisers told him. So, okay. And then we get into the opinion piece. So, I start with like, is this proper lay opinion? Because there's nothing really that suggests Pedro is an expert. So lay opinion is allowed if it is helpful to the jury. I think this is helpful because it's helping the jury understand what the painting's worth, which is key to this lawsuit. Um, but then the next requirement for lay opinion is it cannot be based on specialized knowledge. And I think that's the problem here is this opinion is totally based on specialized knowledge, as evidenced by the fact that he's saying it's based on, the 3 appraisals, right, by these art dealers, right? So improper lay opinion. So then I'm going to be asking, is it proper expert opinion? Which matters because, experts are allowed to base their opinions on inadmissible stuff like hearsay. So that would sort of open up a different door for us. Nothing in here suggests that Pedro's an expert, right? So to be an expert, you have to be qualified as an expert by like your education, your training, your skill, your experience. Nothing in here to me looks experty. Like nothing looks like he's going to be. We don't have any information about him, at least yet. So I'd say he doesn't seem to be qualified as an expert unless they give us something later. And so this is like improper lay opinion because it requires specialized knowledge. It's improper expert opinion because he's not an expert. So I think however you look at this, there's like 2 things wrong, right? One is if you want to describe the art dealers as declarants, this is improper hearsay. And then 2, this is improper opinion testimony for Pedro to be giving unless he can qualify as an expert. So that's how I would come out on that. First, before I conclude, I would throw in legal relevance and, I'd say it's not like unfairly prejudicial or cumulative, et cetera. So, it would have cleared that hurdle. But again, because hearsay, because improper opinion testimony, not okay, shouldn't have been allowed to testify to this. Okay, I think that's all I would do for that question. Then we move on to question 3, Rex's testimony about the age of the painting. Okay, who's Rex? Let's keep reading. Pedro called Rex, there's Rex, a chemistry professor who had been retained by 4 art galleries to determine the age of paintings. So I think this is getting at expert stuff. Rex testified that the painting had been painted within the past 50 years and was a painted reproduction of the original painting. Okay, so, right, so his testimony about the age of the painting, it's new. It's not from a 17th century person because it's within the past 50 years, and it's a reproduction. Okay, he testified that he had used the XYZ technique on Pedro's painting to arrive at his conclusion. Rex testified that he had tested the XYZ technique on paintings of known ages and that the results corresponded with their known age. He testified that the XYZ technique was reliable and used by most experts to determine the age of paintings. After cross-examination, Rex was excused and left the courtroom. Okay, so this whole paragraph, with the exception of that last sentence, which we'll see what we're going to do with that, I don't know, but the rest of this paragraph is getting at expert witness stuff. So Rex's testimony. So first of all, start with logical relevance. This is logically relevant because if it's only, painted within the past 50 years, right, this supports the idea of the advertisement being fraud and, blah, 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 blah. So logically relevant, no problem. Then, what else would I do? I'd say Rex is testifying, so we can run through our witness requirements. Perception, like he perceived the painting, he did the test himself. Memory, he seems to remember doing it. Narration, he's communicating to the jury. Sincerity, no indication that he doesn't get that he has to be honest. And then personal knowledge, he seems to have personal knowledge of like what he's doing with this painting, but also for experts, you don't always need personal knowledge. So that's what I would do with that. I'd get through that stuff really fast because I think the big thing they're getting at here is expert. So to be an expert, right, we said already, you have to be qualified as an expert. So here they tell us he's a chemistry professor. I think you can argue that like the education lends himself to being an expert. I don't know that every chemistry professor is necessarily an expert in dating the, determining the age of paintings. But, I would point that out. And then he's been retained by 4 art galleries to determine the age of paintings. So he has, experience and presumably like some skill and knowledge and maybe some training about this. So I would use that first sentence to say he's qualified as an expert. And then presumably qualified. And then Rex testified that the painting had been painted with, okay. So then after that, after I say he's qualified as an expert, the next thing I'm going to say is we have to determine whether the method he used is acceptable. So in federal court, right, we want to see, are these reliable principles reliably applied? We use this Daubert-Kumho test, right? In California, we use this Frye general acceptance test where the only thing we care about is if this method is generally accepted by people in the field. In federal court, under that test, the Daubert-Kumho, we have multiple factors. So we're asking, does it have a reasonable level of acceptance? Doesn't be generally, just reasonable level of acceptance in the field. Has it been tested? Has it been peer reviewed and published? Is there a low error rate? And so what do we see in this paragraph for that? Okay, so he testified that he's used this technique to arrive. Okay, so that's the technique that he applied. Rex testified that he had tested the technique on paintings of known ages and that the results corresponded with their known age. Okay, so he's tested it, so it's tested. Unclear on how many paintings, just on paintings, but it's tested, okay. So it looks like it was accurate when he did these tests, so I guess you could use that to support the low error rate. I would say, like, well, we don't know if anyone else has tested it, so we also don't know, like, did he only do like 2 paintings? So low error rate to me is a bit of a question mark. And he testified that the technique was reliable. Okay, well, he says so, and used by most experts. So that's that reasonable level of acceptance, used by most experts to determine the age of paintings. Nothing in here about peer-reviewed or published. So I'd say, like, questionable whether this XYZ technique meets the Daubert-Kumho federal standard for being a reliable principle that's reliably applied. But that's what I would do. I think that's all the stuff I would think about for his testimony about the age of the painting. And then, he's not allowed to make legal conclusions, but that's not what he's doing here, so that's fine. I would then say, legal relevance, this doesn't seem to be like, unfairly prejudicial or cumulative or anything like that. Because I guess we already had Pedro say it was a reproduction, but I think that's fine for Pedro to also, or for Rex to also weigh in and say it's 50 years old in a reproduction. So yeah, I think I would just come out with that and then say, depending on how you come out on whether this meets the Daubert-Kumho standard, maybe it's okay, maybe not. And then I would just kind of leave it at that. Okay. Then let's see, what else? Let's move on to question 4. Okay. The excerpt from The Science of Dating Works of Art. Discuss. Okay, so let's keep reading to figure out what that is. Okay, and then we still have this after cross-examination, Rex was excused and left the courtroom sentence. Let's hopefully figure out what to do with that soon. Okay, gallery called Marie, and both parties stipulated that she is an expert in dating works of art. Okay, they're stipulating that she's an expert, so we don't have to go through that expert qualification stuff. She testified that a publication entitled The Science of Dating Works of Art, shockingly, is generally recognized as a reliable authority. Okay, she's authenticated it. Let's see. She then quoted an excerpt from that publication that asserted that XYZ technique is not reliable for determining the age of works of art. Okay, she's trying to impeach Rex's testimony by contradiction, right? He testifies that the technique was reliable, and then I guess gallery, right? They're using her to introduce this excerpt that is contradicting that testimony, and then presumably they also want to use that substantively, but let's see what's happening here. That it's not reliable for determining the age of works of art. Gallery moved and the court received the excerpt into evidence as an exhibit. Okay, so first of all, is it logically relevant? Yeah, it's logically relevant to impeach Rex or, substantively to show that this technique's not reliable, so the jury should just kind of disregard everything Rex is saying. Clears that hurdle, no problem. Next, I'm thinking, impeachment and hearsay. So let's start with impeachment. Impeachment by contradiction. You can do that with extrinsic evidence unless it's a collateral issue, right? Just a collateral matter. I don't think this is collateral. It seems like to go kind of to the heart of the case. So I don't think there's a problem there. I think, yes, this comes in to impeach Rex. So that's not a problem. Then I move on to hearsay. So step 1, is it an out-of-court statement offered for truth as a matter asserted? Yeah, it's out of court. It was written in this publication, Science of Dating Works of Art. It's a statement. It states, XYZ technique is not reliable. Is it offered for truth as a matter asserted? Yeah, if gallery's offering this substantively to say, like, hey, this technique is not reliable. Don't trust the results of, the application of the technique that said it's less than 50 years old, then yes, it's offered for the truth of the matter asserted. So that's, yes, it's hearsay. Number two, do any exceptions apply? And then I think about like my document exception, so it's publication. What comes to mind for me is a learned treatise. So that exception applies to publications that are either relied on by an expert on direct exam, or called to the attention of an expert on cross. I think here, they stipulated that Maria is an expert and she is, relying on this, discussing this. So I think that's fine. I think it would come in under that learned treatise hearsay exception and clear the hearsay hurdle. One thing to note, right, because notice in this last sentence that gallery moved and the court received the excerpt into evidence as an exhibit. One thing to note, I wouldn't actually expect to really have this memorized with everything else that's in your brain going into the bar, but if you know it, our rule for learned treatise is the same as our rule for past recollection recorded hearsay exception. You are allowed to read it to the jury, but they're not supposed to receive it into evidence and like take it with them into the deliberation room. And that's why they've taken the time to give you that last sentence of the court received it into evidence as an exhibit. I think that shouldn't have happened. They should have just read it to the jury. They've done that before on another evidence essay with past recollection recorded, where it was admitted as an exhibit. Same thing. So if you know it, throw that in. If not, who cares? But aside from that, I think it was, technically proper as a learned treatise. So I'd say that. I think like best evidence rule, it's an excerpt. Presumably it's like a photocopy. I think that's fine. I probably wouldn't even IRAC that unless somehow I had extra time. Authentication, she said it's, generally recognized as a reliable authority. So I think that's fine. Maybe the court also could have taken judicial notice of it. I don't know any facts about that, but so I think that's all fine. So I think that's all I would do. Then I would say legally relevant before I conclude. Yeah, I don't see anything like unfairly prejudicial. Like, sure, it's like prejudicial towards Pedro because like it's making his expert look bad, but it's not unfair prejudice. So I think that's fine. So I would conclude on that one that it's fine, but it should have only been read to the jury. If I know that, if not, who cares? Okay. And then finally, we're at the last one. Okay, so Rex's journal article discuss. Okay. Okay, well, let's keep reading. Gallery then offered into evidence a journal article, good, authored by Rex that included a statement that the XYZ technique is not reliable, for determining the age of works of art. Okay, so now this screams to me impeachment by prior inconsistent statement, right? Rex just got on the stand and said he testified that the XYZ technique was reliable. And now they're like, wait a minute, before you testified about that, you previously made this inconsistent statement saying that it's not reliable. So it's impeachment. Again, maybe they're also going to want to use it substantively if they can, to further prove that it's not reliable. Yeah, and now I know what we can do with this sentence of after cross-examination, Rex was excused and left the courtroom from a few paragraphs ago. Okay, so let's go through this. So first of all, is it logically relevant? Yeah, it's logically relevant to impeach Rex by prior inconsistent statement. It's logically relevant to substantively show that the technique is not reliable, right? Which goes to, the fact of consequence of like how old the painting is. Okay, so that's done. Then I'm thinking, I would do the same IRACs of impeachment and hearsay. So if we start with impeachment, we think impeachment by prior inconsistent statement. So you're allowed to bring in extrinsic evidence to do that as long as the witness has the opportunity to explain or deny that prior inconsistent statement. And then, the opponent is supposed to get the opportunity to question him about it. So that's why they gave us this sentence at the end of the second paragraph of after cross-examination, Rex was excused and left the room. So unless they're bringing him back, he is not getting an opportunity to explain or deny his prior inconsistent statement. They should have asked him about this on cross and they didn't. So that's not okay. They cannot use this to impeach by prior inconsistent statement. So not okay. And then I go to hearsay. It's out of court statement because it was made in this journal. offered for truth of the matter asserted, yeah, again, if they're going to use it substantively to show that the technique's not reliable, then it's TMA. So it's not coming in at that point then unless an exception applies. And so here, I would think about learned treatise again. The problem that I see with that is what we talked about already about how the learned treatise technically, right, it's supposed to be either relied on by the expert on direct or, called to the attention of the expert on cross. They didn't call it to his attention on cross like they should have. They're just apparently trying to offer it into evidence like all by itself. So I think that's not okay. It would not qualify here as a learned treatise. So I think not okay. And then also keep in mind, right, anytime you're doing impeachment by prior inconsistent statement, you're probably also thinking, hopefully, about the hearsay exception for prior inconsistent statement. That would not be usable here because in federal court, that has to be under oath, and this is in a journal article. So you could mention that in a sentence if you wanted. So that's fine. Well, not fine, but done, I guess. So I would say not okay for impeachment, not okay as hearsay because I don't see an exception that would apply. So I think not okay. And then legal relevance, right? Like, had it been okay, like it could stay in, I think, because, it seems to have high probative value in terms of impeachments and, substantively, it's, and then I think it's maybe a little bit like cumulative because we just had the excerpt from the Science of Dating Works of Art to prove that XYZ is not reliable. So this is like a little bit of like cumulative evidence, but 403 legal relevance is heavily weighted towards admission. So had it been coming in anyway, I think, it could stay in. And I think that's all I would do with this fact pattern. I think that's it. So yeah, hopefully that was helpful.